Welcome, everybody, to Reimagining Healthcare, a new dialogue with risk and patient safety leaders presented by Medplace. We're excited to bring you conversations with top risk and patient safety thought leaders from organizations around the country. Please subscribe to get the latest news and content. And if you find this valuable, this episode, please share it with your colleagues to get some meaningful dialogues created in your own community. If you'd like to participate as a speaker sometime, feel free to email us at speakers@medplace.com. My name is Jared Bailey. I'm the CEO of Medplace. I'm going to be playing host today. And today I'm joined by Mark Blane, owner of the law offices of Mark Blane APC. Hey, Mark, how are you?
Hey, how you doing, Jared?
I'm well. Let's see, I got a little bit of bio information here. You tell me how close this gets to reality here. But what I've got on you is San Diego, California personal injury and accident attorney, best-selling author too, best-selling legal author. You have to tell me a little bit about that. But Mark Blane specialized in personal injury law since 1999. Your recent book, A Wolf in Sheep's Clothing, recently hit the Amazon.com bestsellers list in the insurance category, and it cracked the top 50 in the personal finance category. I love it. So a little bit of an author.
Yeah, a little bit. Try to get some information out to the public so they can make informed decisions, right?
Yes, indeed. That's great. What was it? This is totally off script. What was that process like? What motivated you to hunker down and write a book?
So the book that hit the Amazon list was a co-op with several other lawyers, and so we just decided to put some information together in different fields for the public to make informed decisions about what they need to do with their legal case. And it's from everything from healthcare, injury, just the broad spectrum. And it did really well on Amazon. And so it's still there if you ever want to get a copy.
Oh, I love it.
So,
I'm going to go look for it right after this.
yeah.
Appreciate that. So, all right. So give me some of your origin story here, Mark. How did you get into injury law?
Right. So I just, during school, I just was really passionate with biology and anatomy. I always loved the law. I knew I was going to be a lawyer when I was a little kid. So I think just merging those three disciplines together was just something awesome to be in personal injury. So that was something that motivated me, and I think it appealed to my attention to detail when it comes to like anatomical features, the biological process, how we get injured, and how the body heals. So those disciplines kind of shape where I am now, I think.
That's great. My daughter, she's 15 and a half, and her team just won national competition for mock trial.
Oh,
So I'm afraid I might have an attorney in
I
my
think you
family
might. Yeah.
before
Yeah.
too long. Yeah, that's great.
It sounds like a prodigious one as well. So
That's right. The apple falls really far from the tree, I have to tell you.
no, hear you.
That's good. So tell us about your role in the workers' compensation process. Like, where do you come in?
Right. So I'm not a pure 100% workers' compensation lawyer. I'm what
Yeah,
you
good.
call, yeah. So I'm the third party lawyer. I go after the at fault party that chose to not follow the safety rule, if you will, that's not connected to the employer. So I go after those third party claims. Not every workers' compensation case is going to have a third party claim.
Yeah.
In California, there's the exclusive remedy rule, which I'm sure it's mimicked by maybe every other state in the United States, where if you can't go after a third party, then you're limited, your recovery is limited just to the workers' compensation process. So I will go after the third party that caused the injury, and that could be, if we use the car crash as an example, let's say you're a UPS driver, you're delivering packages, you get injured in a car crash, you got two claims in California, you got your workers' compensation claim, and then of course you got that third party claim to go after the at-fault driver. I'll take the driver's side. And then if needed, there'll be a lawyer for the workers' compensation side.
Got it. So what does it mean to you to be a voice of the injured person or the injured worker, if the case may be?
You're right. So for me, it's a great privilege and honor to be in this position to help folks who just have been injured. A lot of times, it's very expensive to even get a lawyer. That's why I love the fact that in personal injury law, we can offer the contingency fee relationship. This allows people from all financial means to have access to the courthouse, if you will, the key to the courthouse. But because of that, and because they're injured, and a lot of times I take serious injury cases, it's a great responsibility as well. So not only am I honored to be that voice for the people that need it, but I
Yeah.
feel like I do a very good job and I'm very detailed in what I do. And for that, it's an honor. So
I have to imagine you have to have a lot of empathy in your position, right? I mean,
yes,
this is probably the scariest time for some people.
yes, empathy is very key, not only to helping your own client that's been injured, but if it goes to trial, believe it or not, you got to have empathetic listening to the jurors.
Hmm.
So it goes full circle. It starts with your client as a human being who's been injured by someone who just wasn't following the safety rule, and then we have to communicate that and keep that relationship all the way through trial if it goes that far. And
Yeah.
then at that point, we've got to then listen to the jurors and jury selection to make sure we're getting the right fit for that for your particular client. So I think empathy and empathetic listening and is a foundation to not only holding that relationship key throughout the process, but also through fruition of the entire
Having
process.
an effective outcome at the end of it
Yeah,
as well. Yeah,
absolutely. Yeah.
that's great. So California can be, in a lot of ways, it's got similar injury law systems and laws as other places. In other places, it's a little bit different. We have a national audience. What would you say is maybe different about or set apart from California's injury law
Well,
system?
I can comment on the perhaps the American Medical Association impairment rating. So the California workers' compensation system, I think in mid 2006 or 7, adopted the AMA 5th edition for their impairments, which is really coincidental for me because I've been using the AMA guidelines since I've been a personal injury lawyer.
Mhm.
And not every case is going to warrant a AMA finding of impairment, but I it's great to hear that the workers' compensation system in California does allow it because I use it all the time in my practice. And
Yeah.
so, just briefly, I'm sure your audience knows the AMA 5th edition guidelines, but it's just the objective finding, the most objective way to document any impairment, so you can argue for that future pain and suffering instead of just shooting from the hip, if you will. And also, it gives a basis for the juror or the mediator or judge for accounting for pain and suffering and whatnot. So I think that if California is the only state that, or one of the many states that has the AMA 5th guidelines, either it's set apart from the other states that don't, or maybe all the other states use it as well. But that's one thing that comes to my mind is that.
Yeah. No, that's interesting. Yeah, and I don't know how many states have adopted that, but if anybody watching this kind of wants to leave in the comments in their state what you see as what your state's adopted, that'd be super interesting for me to know. Now, and we deal with here at Medplace, we deal with IMEs. I mean, you and I were talking before the show. We've got a
Yeah.
platform where doctors around the country basically get connected easily with companies who need their advice on things. And so IMEs is something that's top of mind for us. And it might have even been how we found you, but you've created several articles and videos about IMEs and specifically the drawbacks for them. And right. So
Right.
can you unpack that a little bit for me?
Yeah.
Like what makes a good IME or a bad one, like from
Right.
your perspective?
And it's not to say that every defense medical, and we call them defense medical exams on the plaintiff side, but it's not to say a defense medical exam is going to always be bad. What becomes bad is when you have a doctor that is routinely abusing the biases, if you will, that's inherent within a defense medical exam routinely. In those cases, you have to be watchful. That's why it's good to have your ear to the community of your colleagues, because we do talk. We have listservs here in San Diego. And then we start seeing who are the new defense doctors that the insurance are using for these defense medical exams. And so depending on which doctor that's going to be, I'll go to that exam. Most of the time I'll be going to the exam with my clients, and
Yeah.
it's very, I don't go in there with, hey, I'm recording this, unless I absolutely need to, but that's really rare. I just go in there with the expectation that we're both professionals, this defense doctor's doing their job, and they're going to write the report based on the medicine, not based on their bias. And then if it is a biased type of report, then of course either we settle the case or we'll let the community of the jurors decide who's more credible here. But I think that's the only part where it gets bad is when you have a defense doctor that's beholden to the insurance company's interest to get more business, if you will, because they're providing these more of a biased opinion. But there are a lot of good defense doctors I've worked with in San Diego over the years that are not in that category, I must say, and that's nice to see because we're all professionals just doing our best for our individual clients at the end of the day.
Yeah, that's great. And it really is interesting. Like, coming from a technology perspective, I talk a lot about system design. And
Mhm.
when you see flaws in a system, how do you design for those flaws, right? How do you create systems that either mitigate bias or eliminate bias, or at least even just measure or account for it? All really interesting questions to ask as you're looking at, I think what both sides are interested in is a fair system that achieves justice at the end of the day. And what things in it are just sort of inherently built with flaws, I think is an interesting question to ask. Because I think
Absolutely.
at the end
We
of the day,
both,
everything's solvable, but
right,
are we
right.
looking at the right problem?
And we both want a fair fight. The defense and the plaintiff bar want a fair fight. And and I think it just serves the interest of justice at the end of the day if there's a fallacy going on and it's being repeated. But that's why we have a jury, right? Because the juries can see through that and they can assess and use their common sense. They've been around for a while. They can make decisions. One person making one decision is not as good as 12 people collectively making a decision. And so
Yeah.
that's kind of the process. Yeah.
Yeah, well, again, I think it all goes to system design. Like, how do we,
Yeah.
it's why we have a jury of our peers, right? It's to help counteract some of the issues that happen when you don't have those things in place.
Right. Best
So,
system in the world, too, I might add.
yeah, yeah, it's interesting. I haven't spent enough time studying other systems to really kind of look at what other experiments are going on, what other things have happened, and at the end of the day, what's the data show about how these
Yeah,
different approaches are working?
that would be interesting. I know that when it comes to jury trials, we're the only last bastion country that allows it for both criminal and civil matters and all matters. For
Oh,
example, I think England, they still have, of course, civil jury trials, but only for product defect cases. I don't think they have it for injury cases like we do in the United States.
no
And of course,
kidding.
yeah, and I know that India was interested in the San Diego court system about 10, 15 years ago. They did a study of how efficient we are with our court system here, and they want to emulate that.
Well, that's great.
So, yeah.
Okay, all right. Well, so we're talking about system design and friction inside of the system. And that's part of the system, right? If you create two sides and you create friction between the two, you're gonna, it can be uncomfortable, but it's also, part of coming to the right answer. Is it possible to get on the same page as defense counsel in the interest of the injured worker? Like, what does that
Yeah.
look like?
Yeah, absolutely. Now, like you have good and bad defense doctors, occasionally you have a good and bad defense lawyer. Like I said, we're mainly professionals, and that's something that's neither here or there. I always get along with defense counsel whenever possible, and if there's any disputes that come about with that relationship, it's usually in discovery, and so we'll have to go to the judge and figure out discovery, which happens rarely. And of course, judges do not like that. They want this to be seamless and efficient, and there shouldn't be, don't drag down my docket with discovery issues that you gentlemen should, or ladies should have all figured out.
Hmm.
But nonetheless, from time to time we do have a defense counsel that try to test the code and stretch it to certain aspects and what's allowable, and we do have to meet with the judge on that. But that just comes with time and experience, and I think as I grow with that, it's just something you just have to recognize that it's adversity in life. We don't just have it in an injury case, but life's not perfect. We're not living in a perfect world. So I think just press on through that, and it always gets resolved.
Yeah, oh, that's great.
Yeah.
Well, so life care planning is always a topic. It's a topic on both sides. It really
Yeah.
sort of defines the debate in some cases, right?
Right.
Um, what Get any perspective on that? Are you playing any role in the life care planning process yourself?
Yeah. As far as not every case is going to need a life care planner, of course. Not every surgery is going to need one, but there are cases that do need one, and those are the cases that are the more serious injuries, or injured cases I have, and I'll use that to my experts, life care planners, to figure all out, because it is detailed, as you know. I had one case recently where the guy fell from a 16-foot defective ladder, had 14 surgeries, went almost passed away in 2 of the surgeries. So of course we got to have a life care plan on this one. So yeah, I leave that to the experts to get those details in line, and that is part of the damages that the client is going to need to depend on, either through mediation, settlement, or trial. And we have a good team of life care planners that I sometimes employ on a case here in San Diego, and they do a terrific job. And if it goes to trial, they're very good with testimony, because a lot of times it's about communication with the jury, because there's a lot of technical terms with life care plans that need to be explained.
No,
So
that's
yeah,
great.
so we touch on it, but like I said, I just don't, of course, I don't do those. That's why I got experts that do it, but definitely
Yeah.
something that we have here in personal injury.
It's top of mind for us because we're getting asked more and more by clients if we would expand into that space. Right now, we have a lot of doctors and nurses, right? Because you need clinical
Yeah,
opinions on things.
that's right.
But there's other types of experts, or there's other types of doctors and nurses that have specific backgrounds that lend themselves to be able to do certain types of life care plans, or especially when you have certain kinds of injuries and things like that in place. So what I found coming from seeing other industries, I've done some other stuff in healthcare, but being here at Medplace now, like seeing how healthcare works, it's amazing how much inefficiency and friction there is in the marketplace. I mean, you have this expertise in the world to be able to do certain types of things, but actually finding them is and engaging them, and putting them to work and getting the result you want out of them is challenging. And that's what you find with a marketplace. There's a lot of friction involved, and you see in other industries how they've solved it by making these kind of marketplace plays to be able to do that. So, and it's top of mind. I hear it a lot, and it is sort of especially if it's the type of case that requires a life care plan. It's such a critical piece in the middle.
Right.
How both sides are approaching it is interesting to me.
Yeah. I usually find them needed on multiple surgery cases,
Yeah.
a lot more than on single surgery, but definitely an important piece of the damages that a person has the right
Yeah.
to claim.
So I always like to ask this question. This is going off script again too, but you've been in the industry for a while, and you've seen, I'm sure you've been frustrated with things that, uh, take a long time or are difficult to do. Is there any place where technology should be, like I've got this great technology background and platform. What are the things, if you had a magic wand and you could have technology sort of solve for something industry, what kind of things come to mind, if any?
Well, I do a lot. On occasion, we do focus groups, so having good video, audio equipment is always some tactical equipment we need to have employed, especially on novel issues that come about with personal injury law.
Yeah.
I think with trials, don't need to get too fancy with it. Some jurors, that's changing. Having a PowerPoint is a lot more entertaining in presenting evidence than if not having one. But then again, there's bad PowerPoints and there's good PowerPoints. So as far as that, here's one that comes to mind. Collision reconstructionists, they're getting a lot better in terms of graphics, in terms of reproducing the let's say it's a major car collision or multiple car collision event. Yeah, those are good. And the jurors respond, and focus groups respond really, really well to really good produced reconstruction, not only with the collision itself, but also the plaintiff and the way the plaintiff body moved. And you have these anatomical features to these videos, and so that's something
Really
that's changed in the last 10 years.
really illustrates for the lay person, like what actually
Yes.
happened and what's really material value, just to understand it. And also seeing this in other industries, how visuals can be used to storytell and really help anchor people in concepts that then can travel through the rest of the trial and be used at closing, right? As just kind of that anchoring sort of mental thing. It's not used often enough, or when it's used, I don't see it done very well in the courtroom setting.
Right. There's a book on this called, I think it's something like "Don't Tell Me, Show Me."
Yeah.
And that's something that you're kind of touching upon there with your point. Yeah, you want to it is part of the video reproduction is a part of the injury story itself. And if you can interweave that with your story, it's going to communicate much more effective to the jurors or mediators, because I've seen good presentations that actually help settle cases in mediation. You don't have to go all the way to a jury trial. So absolutely. And that's what because as a plaintiff lawyer, I'm ultimately a storyteller.
Yeah.
And I'm taking the jury on a journey through a story, and they're going to finish the final chapter.
Yeah.
Right?
I've mentored hundreds of startup founders over the years, and startups have a problem with stories. They have to take something that nobody's ever seen before and try to somehow tell the story of why you might need this thing, right?
Mm-hmm,
You
right.
never had it before, and all of a sudden they need to convince you that you need it, right? This piece of software, this app, or whatever. It's a story.
And you didn't know you needed it before, right?
That's right. Yeah, and these could be concepts that are really complicated, and so good storytelling means that you can take something even potentially complicated and explain it in a way that your grandmother can go, oh, I can see the value of that. That makes sense, right? And that's a hard thing to do. And as you're working with juries, you're going to have a whole cross section of, Americans that you're having to bring along, and they're all starting from different starting places, right? But a good story with understandable data behind it can really be impactful.
We are wired for storytelling, hearing a good story. Ever since we're little, the first thing we hear are stories from our mom and dad. So
that's right. Our brain, our brain clicks over into a different position when we're in story listening mode, right?
That's right.
It's really fascinating.
It is.
Well, that's great. I actually know somebody who does really good visuals for courtroom settings. So if you're ever looking for anyone, if any of you in the comments are like, hey, that would be great. Tell us in the comments. But okay, great. So Mark, anything else that you'd like to touch on? Is there a drum that you beat all the time that you're like, as much often as I can get this message out, I'd like to?
I think I just tell people, look, not every case is going to need a lawyer, right? But every case deserves good legal counsel, and that way, so you can make an informed decision on what you need to do with your options. So that's one thing I drumbeat all the time, not only, just not only with my marketing, but when I meet a client or for the first time on the phone, say, look, you may not need a lawyer here, or you do, and here's why. And then I also offer free ebooks on my website for anyone who's interested in knowing more about that. So
that's great. I love it.
Yeah.
I love it. Anybody who's willing to take the time and effort to write a book has had enough to say at that point to actually put it down.
I mean, you see the defense point of view all the time. So I just wanted to put in paper, look, this is what you're going to expect if you have this situation for you or your family. So yeah.
That's great. Well, Mark, it was a pleasure.
Likewise.
Getting to hear a bit of your story today, and thanks for touching base with us. For those of you who want to connect with Mark, I think I've got your LinkedIn. I can post that. We'll put your contact information up in general, but generally speaking, where should they reach out?
Oh, they can just email or call me. You can put my LinkedIn. I'm all over social media. YouTube.
And your website is?
BlaneLaw.com.
BlaneLaw.com. That's BLANE.
Yeah, no I in the Blane. No I in the Blane. Yeah.
That's always good to remind people. Well, listen, everybody, thanks for listening to Reimagine Healthcare, a new dialogue with risk and patient safety leaders. Subscribe and share if you found it valuable. And if you'd like to participate again as a guest, just email us at speakers@medplace.com, and make sure you do follow Mark and connect with him on LinkedIn. And thank you, Mark, for being my guest today.
And thank you for the invite. I really appreciate you doing that. So thank you.
Anytime. All right. Good luck. And I'm sure we'll be in touch.
That sounds great. Thanks, Jared.
All right. Bye-bye.
Bye-bye.